Dear interpreter, I'm gonna share with you this video. We as an interpreter in North America, most of our bulk of the interpretation of simultaneous and consecutive interpreting, our target language is always our native language. When we reverse interpretation, we always have issues. For this reason, I came across very important video online from Arabic to English. So I did uh, transcribe and translate this video. It's called The Art of Pleading by a lawyer named Mohammed Manna. And this is a high register, by the way, and there is a different, we can hear in this video, there is different in terminology in the legal system, terminology between Canada and US. For example, felony and misdemeanor. In Canada, you use indictable offense and summary conviction offense. So I did use both, but mainly I use the U.S. legal terms for felony and misdemeanor. So this is for education purpose. I would be doing simultaneous interpreting, but I also would like you to use it for educational purpose only. Thank you. Just watch.
The court exercised its discretion to reclassify the charges against the accused to ensure the pleading aligns with the correct legal framework. However, under Article 307 and the referral order, both we and the court are bound to the original terms of the trial, as long as no other thing have been presented. The scope of the trial is in the crime of attempted murder, stipulated and presented by the accused in the referral order. The defense requests the acquittal of the defendant of the charges brought against him based on the following grounds. First, the invalidity of the evidence derived from the prosecution witness testimony, as it's established on malice, fabrication, and lack of plausibility. Furthermore, the injury are pre-existing, as indicated on page 33 and 34 of the record, pertaining to misdemeanor cases previously filed by the victim against the defendant. I plea the lack of seriousness and the non-existence of investigation, as well as the invalidity of the investigative presumption, as it was based solely on the victim's statement without the corroboration of a single witness, and without any of the proper legal elements of the investigations as specified in Article 21 and 24 of the legal procedures. Regarding the case, the defense petitioned the court to amend the legal characterization and charges to summary assault under Article 242, paragraph 1 and 3, to the extent of proven certainty, but the defense maintains this view on a legal characterization of the charges, as filed asserting the failure to establish the basic element of the offense of attempted murder in both its physical and moral components, due to the availability of voluntarily withdrawal by admission of the victim that the accused had insulted me and run away. Had the intent to kill, he was fully capable of presiding in the assault. There was no evidence that the crime was interrupted or failed due to circumstances beyond the perpetrator's control. Furthermore, the defense pleads the severance of the causal connection based on the circumstance of the contradiction and inconsistency between the verbal evidence and the technical evidence, as well as implausibility and absolute impossibility of the incidents occurring as described in the case file. The defense relies on the forensic report provided on page 60 and 61. The healing of the victim suffered injuries according to the first clause or paragraph of the opinion clause. Another forensic medical report, 48, also indicated that the date was the 1st of February 2021, that the wound is an old one, as established and presented before the Honorable Court. Mr. President, Honorable Distinguished Counsel, to begin with, and we will not elaborate further on calling to the facts of the case. But it seems that there is no any disagreement, and it seems that there is no resentment and no lying in waiting for the accused to frame him and he is even enlisting to help of others, contrary to what the defense lawyer said in the civil case, that there was another role, but he exploited it to create a fabrication by agreement and thoughts. He was the one who planned and wanted to get rid of the accused. He had this accusation. What is established before the court is that he stated without a motive that the inconsistency and contradictory regarding the driving motive behind the commission of the act, that the motive is not the element of the crime. However, it's one of the pillars of the intent to kill when we reach to that point. Did the accused intend to assault by beating him to enable him to dispute the misdemeanors referred to by the provisions as stated on page 33 and 34? Or did the accused wanted to kill him and not back down? It would be contradictory if the accused wanted to concede. He would have been keen to preserve his life. If the accused intended to kill, what prevented him to complete of that killing, especially since the victim, when questioned about his statement by way of inference, and at the start of the investigations, he said that he hit me and then fled. He amended his statement and he was aware of the assault, but it was not proven that there was a witness who intervened to stop the accused action. Then, in this case, when we talk about the evidence from the outset, the prosecution has failed or has relied on supporting the list of evidence supporting the victim's statement. Are the victim statement far from suspicion? No. I have firmly maintained the argument of malice and fabrication, asserting that the victim has a vested interest in leveling multiple accusations against the defendant. The victim, harboring a predatory instinct for revenge, was the one who initially attempted to assault the defendant in a previous incident. However, the defendant prevailed over him, causing a deep-seated grievance. He then sought the help from another man who was a friend of his. He is the son of the victim, according to Rule 28, who pointed him out and wanted to assault him while he was in the street. He overcame both. The incident, which my friend regretted, was not brought before the criminal court and was described as a misdemeanor. The disputes here are established, long-standing, and documented. These matters are presented to Your Honor to demonstrate that the victim's testimony does not align with the correct application of the law. For a testimony to be valid, it must be free from any suspicion. But if that testimony resembles maliciousness, is not acceptable as evidence or proof in the court. If the testimony is contradictory and inconsistent regarding the motive in some way, they presented him with a plan, saying they were forcing him to concede. On another occasion, he claims that there was an intent to kill. This what is established before the court. Such contradiction and inconsistency within a single testimony strip the criminal evidence of its coherence and consistency. This is the issue of the court. Discretionary powers in assessing the statement of witness. I forgot to speak about the element of premeditation. We must ask, who sought out the other? Although the prosecution has characterized the act as such, its characterization is not binding upon the court, pursuant to Article 308 of the Criminal Procedure Code. Because the prosecution described the accusation after the court ruled that the defendant's assaults on the victim was premeditated and deliberate. We must address this matter before delving into the evidentiary basis of the charges. I must first address the investigations. Did the investigation identify a single witness They did not. Did the investigation lead to a seizure of the weapons used? They did not. On what then did the investigations rely? They relied solely on the victim's statement. Had the investigating officer identify a witness? Why was such a witness not presented? If the victim falsely claimed that the neighbors witnessed the incident, why did he fail to identify or name one neighbor? Especially he saw the assault, they saw the assault, or they could testify to the acts of the incident. If the matter is suspicious and the suspicion is presented before the court, then this related to the forensic. Consequently, the legal inference has failed and the matter is now entrusted to the court discretion. Moving to the evidentiary basis of the charges. I stand before the court of law. The prosecution stated that the victim resides in the house of the defendant's uncle. To clarify, the victim was merely renting a room in that house, which he later vacated and frequently visited it. Meanwhile, the defendant himself resided in his uncle's house. I am the one present in the house. I am the accused. However, is the present has decided that upon my return and entering the residence, I found the accused? Where was the premeditation and prior thought to commit the crime? Is far from being a coincidence. The defense, with the leave of the court, proved that interviewing the victim by confessing to the accused that it is not an act of surrender, but he denied the premeditated claims that it was a coincidence. The accused was at the door of the property and then the altercation happened. This is what was observed and stated in the exhibit. With the permission of the court, that the premeditation is personal circumstances, and the circumstances of premeditation, as we have learned from the Honorable Court, premeditation required that the existence of determined intent to commit the act, coupled with deliberation, reflection, and preparation of a weapon for the specific crime. Otherwise, premeditation cannot be established. The defense further contends that this element is absent, as both its physical and temporal component have not been met. That was regarding premeditation. As for lying in wait, it is an objective circumstances that must satisfy both temporal, moral elements. It is assumed, as I have stated, that I reside in that very building. It is my uncle's house, and he has an apartment. It is correct to say here that the place where I came by virtue of logic necessity, I must have been. I was lying in wait at a residence of a suspect who had thought me out himself. The matter is utterly unacceptable and rejected. The prosecution erred in its legal characterization by adopting the victim's narrative and following the path of his unsubstantial claims in the investigation. Driven by the victim's intent to fabricate this case, we now see a multiplicity of forensic medical reports within the case file. With the court permission, the defense shall now address the issue of attempt. In legal terms, we must distinguish between preparatory acts and commencing of execution. An attempt occurs when the perpetrator begins the execution of a crime, but the act is either interrupted or fails to achieve its intended result due to circumstances beyond perpetrator's control. The matter here, after obtaining the court's permission, requires first that the commission of the act must be proven by conclusive evidence that supports the victim's statement. Therefore, we do not rely on investigation in the absence of its sources as it is presented. Therefore, it must be established that there was a premeditation and preparation prior to the commencement of execution. Furthermore, regarding commencement of execution, which is which was either interrupted or failed to achieve its effect due to circumstances beyond the perpetrator's control, as established by both jurisprudence and judicial proceeding. However, in the details of the victim's testimony, as found in the case file, he stated that the defendant assaulted him and then left me and ran away. The law regarding attempt defines what is known as voluntary withdrawal. Voluntary withdrawal occurred when the perpetrator had the capacity to continue the assault but chose to abandon it of his own free will. In this case, there is no basis for the charges of attempt, for punishable attempt is one where the act is interrupted or fails to achieve its result due to circumstances beyond the perpetrator's control. The defense contend, based on the witnesses' testimony, that the defendant's withdrawal from continuing the assault negates the intent to kill by way of logic and rational necessity. Because if he had intended to kill, he would have continued and persisted with the assault. Therefore, with the court permission, we are before the commencement of execution that has not been proven to either interrupted or failed due to external factors. The matter is submitted to the court discretion. In relating to the intent to kill and intent to kill after if it has no definition, he said that the issue is to elevate and infer from the indication and presumption of the accusations, and its supporting argument has been presented to us. The victim's evidence was that the accused left him behind and ran away. Therefore, the intent to kill must be addressed through clear indication, presumptions, and conclusive evidence, free from any blemish. This ensures that the judgment, finding, and its subsequent reasoning are rigorous, sound, and sufficient to sustain the ruling reached by the court. The matter here pertaining to the intent to kill, in this regard, I recall the word of our late professor, Dr. Raouf Abir, who described it as being of the treasury of the eyes. If I were keen on him waiving his right and reconciling with me in the misdemeanors, it is logically inconsistent that the person I seek a settlement from would be the same person I intend to kill. How then would come forward to waive their right? And how could I have known that I would be moving from the jurisdiction of a misdemeanor to that of a felony? Consistently, the motive for committing the act is non-existent. The defense contend that according to the precedent of the Supreme Court, the essential element of the intent to kill include both the motive to act and the instrument used. The motive here is also a point of contention. It is entirely non-existent. There was absolutely no reason or jurisdiction or justification for the defendant to kill the victim from any cause whatsoever. Firstly, why? Since the victim was already the complainant in the misdemeanor case and was not the defendant who wants revenge. Who is the one who would reflect and plot? And who wants revenge is the accused person who previously overpowered the victims in the assault incident. Or was it the victim who sought revenge and retaliation? As I have demonstrated, accordingly to a legal position have been reversed, and in this matter the role of the victim was reversed and he himself became the accused. But our esteemed court, with its wisdom and cites that reads between the lines, the court will discern the true facts of the case. The defendant further pleads the invalidity of the evidence derived from the submitted forensic medical report, which have been tampered with by the victim when the incident occurred on November 5th, 2020. Yet the victim's first appearance before the Forensic Medical Authority was not until February 2nd, 2021. Upon reviewing page 61 of the case file, with the court permission, this specific report stated that the aforementioned individual had completely recovered from injury in the head, chest, and abdomen. The defense said that the forensic medical report is devoid of any evidence showing that the injury the victim recovered from were located in a vital area. Consequently, the forensic report cannot be used as evidence to establish a murderous intent. So how is it then? With the court permission, I stated from the beginning of the proceeding that the attribution was incorrect and the power to assign the matter to a trial court. While we have presented our oral argument in the light of the referral order and addressed the evidence brought forward, I have firmly maintained, in conclusion, I held on the interpretation of the causal connection between the alleged act and the resulting injury. Therefore, based on all I have mentioned, I leave the matter to the court wisdom. I shall say no more, as I have summarized my defense in the argument presented before your honor. For you are the most diligent defender of the accused, even before his own counsel. I conclude